Good afternoon, my friends, and welcome to Lawyered Up. I'm Patrick Bean. I'm a Florida trial attorney and former police officer, and I bring you news about firearms and the Second Amendment from around Florida and around the country. We have another 2A win for the good guys out of the Northern District of Texas in the case of Firearms Policy Coalition and two minors versus Stephen McGraw in his official capacity as the director of the Texas Department of Public Safety. And so what is that all about? Well, Texas has a law they enacted prohibiting 18 to 20-year-olds from carrying a handgun or applying for concealed weapons permits. Florida has a similar law. We expect it to fall also. The judge in the Texas case enjoined Texas from enforcing that law. And let's take a look at the actual text of the order. All right, we should have Judge Pittman's order up on the screen now. In this case is in the Northern District of Texas out of Fort Worth. It's the Firearm Policy Coalition and versus Stephen C. McGraw in his official capacity as director of the Texas Department of Public Safety. And you can see the basis for the opinion and order. And they ask the issue of, does the Second Amendment protect the right of the people to keep and bear arms for self-defense? Yet Texas prohibits law-abiding 18 to 20-year-olds from carrying a handgun for self-defense outside the home. So that's what the issue that the court is addressing in this particular case. And you have the basic analysis on page 2. The issue is whether prohibiting a law-abiding 18 to 20-year-olds from carrying a handgun in public for self-defense is consistent with the nation's historical tradition of firearms regulation. Based on the Second Amendment's text, as informed by the founding era history and tradition, the court concludes the Second Amendment protects against this prohibition. Texas statutory scheme, therefore, must be enjoined to the extent that law-abiding 18 to 20-year-olds are prohibited from applying for a license to carry a handgun. And you can see there where the influence of Bruin is coming in. And the jurisdiction, of course, it goes into a long jurisdictional statement. Of course, the court has jurisdiction in this particular case. And it goes on to cite the Second Amendment as a well-regulated militia necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And of course, it goes on to explain why 18 to 20-year-olds are included in the We the People. Rather than the means in the scrutiny test, the court must assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. This is citing Bruin. Stated another way, the court must first interpret the Second Amendment's text as informed by history, and when the plain text covers the individual conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is only consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. That's all citing Bruin, and that's the rule made in Bruin. Are 18 to 20-year-olds part of the people mentioned in the Second Amendment? As explained below, the court concludes that they are. Of course they are, because you had the Militia Act, and 18 to 20-year-olds were required to be in the militia. And this is just a judge analysis. It's a very good analysis. If you're into reading court cases, you should sit down and read it. But let me get to the bottom part with the meat in it. So now we come to the order on page 22. The court orders it to the extent the Texas statutory scheme, penal code, and it cites the penal code, prohibits law-abiding 18 to 20-year-olds from carrying handguns for self-defense outside the home based solely on their age. This statutory scheme violates the Second Amendment as incorporated against the states via the 14th Amendment. The defendants and all their officers, agents, servants, employees, attorneys, and other persons who are in active concert or participation with them are hereby enjoined and restrained from enforcing Texas statutory scheme against law-abiding 18 to 20-year-olds based solely on their age. This injunction is hereby stayed for 30 days or pending appeal for the duration of the appellate process. So if the state of Texas doesn't appeal within 30 days, this injunction becomes permanent, or if they appeal, it becomes stayed for the length of the appellate process, for the time that it's in the appeals court. So like I said in the beginning, Florida has a similar law that prohibits 18 to 20-year-olds from buying firearms. And why? This is a very good analysis. The judge took a lot of time and really went into this case, and I really like the opinion, so take a read if you want to. I'll link to the opinion down below. Remember, be careful out there, always lawyer up, and I'll see you next time.